All right, today we're diving deep into a landmark Supreme Court case, but we're going to look at it from a really specific and powerful angle, the dissent. We're going to deconstruct Justice Sotomayor's dissenting opinion on college admissions, step by step, to really understand the logic behind it. So let's just jump right in with the opening line from the dissent itself. This is not subtle. It's a powerful declaration that frames the majority's decision not as some minor legal tweak, but as a U-turn, a full-scale reversal of what the dissent sees as decades of hard-won progress. To really get this, we're just going to follow the dissent's own roadmap. We'll start with how they see the Constitution's guarantee of equality. Then we'll go back in time to see what they argue the 14th Amendment was all about. We'll look at the legacy of Brown v. Board of Education, unpack why diversity was ever a compelling interest, and finally, see how they connect all of this to the reality of today's world.
Okay, first up, how does the dissent even frame this whole issue? Well, for them, it's not about giving anyone an advantage. It's about a constitutional promise. Here is the core idea right from the start. The dissent is basically saying that the majority's colorblind approach is the exact opposite of what the Equal Protection Clause is supposed to do. The logic is, if our society isn't actually colorblind, how can a colorblind rule create fairness? They argue it doesn't. It just locks in the inequality that's already there.
Now, this is where it gets really interesting. The dissent doesn't just look at recent court cases. No, they get in a time machine and go all the way back to the post-Civil War era to argue about what the 14th Amendment was meant to do in the first place.
The whole case really hinges on what these words mean. And the dissent's whole point is that you can't just read them in a vacuum. You have to understand the specific historical problem the authors were trying to solve right after the Civil War.
And this slide just lays out the fundamental disagreement perfectly. The dissent makes a huge point that the very same Congress that wrote the 14th Amendment actually considered and then rejected language that would have made the Constitution explicitly colorblind. So you have to ask, why would they do that? Well, the dissent's answer is simple, because they knew they needed to pass laws that were race-conscious to fix the damage of slavery. And they don't just say this, they bring the receipts. They point to actual laws passed at the exact same time. You have the Freedmen's Bureau Act, which set up schools specifically for Black Americans. You have money set aside just for colored soldiers and sailors. The dissent argues this isn't some contradiction. It's proof of intent. The goal was never to ignore race. It was to actively fix racial inequality.
Okay, so with that historical context set, let's see how the dissent uses it to talk about maybe the most famous desegregation case in American history. They argue that the majority is really misreading the legacy of Brown v. Board of Education.
The dissent basically traces this legal domino effect. They say Brown was just the first domino to fall. For decades after, the court kept building on that idea. It wasn't enough to just say segregation is illegal. Cases like Green said schools have an affirmative duty. You have to actively fix the problem. And the dissent sees the modern university cases as just the next logical step on that same path. This is such a powerful move in the argument. They invoke the name of Thurgood Marshall, the guy who literally argued and won the Brown case before becoming a justice himself. They're essentially saying, hey, the architect of desegregation, he himself believed that you couldn't just ignore race to achieve equality. It's a huge appeal to history and authority. So that brings us right up to the modern cases, which for over 40 years were all built on this one key legal idea, that having a diverse student body is a compelling interest for a university. And here's the thing, for 45 years, the court had recognized all these very real, tangible benefits. It wasn't just some feel-good idea. Precedent said diversity literally improves education, breaks down stereotypes, and better prepares students to become leaders in our society. The dissent argues that the majority just kind of tosses all of that aside without a good enough reason. And finally, we get to what might be the most powerful part of the dissent's argument. They say, okay, let's put the law books down for a second and just look at the world we actually live in today, long before any kid even thinks about filling out a college application. The dissent kicks this section off with a really stark look at our K-12 schools. Citing government reports, it points out that segregation is still very much a reality. We're talking about half of all Black and Latino students attending schools that are overwhelmingly non-white. The point is, this isn't ancient history. This is the pipeline feeding into our universities right now. And, the dissent argues, it's not just about who you sit next to in class. This segregation is directly tied to resources. These schools have way higher rates of poverty, which means unequal starting lines for students from day one. We're talking everything from funding and teacher quality to access to AP classes. Then they add this piece of the puzzle. I mean, think about how complicated the college application process is. Well, this data highlights another systemic hurdle: huge differences in how much experience families have with higher education in the first place. So you see the picture they're painting, right? You've got segregated schools, unequal resources, and these big gaps in family experience with the whole system. When you put it all together, the dissent's argument is that these factors stack up and make a supposedly race-blind process totally unfair. They say ignoring these realities doesn't create a true meritocracy, it just rewards the people who got a head start. And this quote just brings the whole argument full circle. It connects the history of the 1860s right to the data of today. It's the core philosophy of the dissent in a nutshell. You cannot fix a problem by pretending it doesn't exist.
And so, this is the fundamental question the dissent leaves us with. It completely reframes the debate. Is equality just about applying the exact same rules to everybody no matter where they started? Or, as the dissent argues, does equal protection actually demand that we acknowledge and actively address the deep inequalities that are still with us?